Good evening to all. Welcome to the first ever webinar organized by Brainware University Library and Library of Brainware Group of Institutions. This webinar is about digitization and copyright, the issues and challenges regarding this. Uh, We are proud that we have with us our eminent speaker, Dr. Bonali Roy Choudhury, Assistant Professor, Department of Library and Information Science, Netaji Sugar Open University. We have with us our Pro Vice Chancellor sir of. Yes, I'm audible. Hello.
Yeah, you are audible.
I'm audible.
Yes.
You are audible.
Yes, continue.
So,
Yes, Sujan, continue.
we have with us our Pro Vice Chancellor sir, Dr. Subhashish Banerjee, Brainware University. We have with us Dr. Shankar Gangopadhyay, Director Research, Brainware University, and Ms. Bandana Basu, Librarian, Brainware University. The next part of this program will be conducted by Ms. Bandana Basu, Librarian, Brainware University.
Good evening to all. I am Bandana Basu, librarian, Brainware University. Now I request Dr. Subhashish Banerjee, our Pro Vice Chancellor, to deliver welcome address. Sir, please.
Thank you, Vandana Madam. I welcome Dr. Bonali Roy Choudhury for this special occasion to be here as a guest speaker. I would like to introduce Dr. Roy Choudhury. Dr. Bonali Roy Choudhury, she's presently working as Assistant Professor of Library and Information Science, Netaji Subhash Open University. She is also former librarian of Acharya Jagadish Chandra Bose College, Kolkata. She is concentrating on issues relating to development and implementation of open educational resource, that is OER policy, OEP and OER repository, and develop open educational resource. Repository of Netaji Subhash Open University under the project supported by CMCA COL. Another important work of content contributor of OEP is resource optimization, ISBN 97892C 10076 8th edition. This publication is available in open access under the attribution share license and was published on 2015 under UNESCO. Her area of interest are open access, open source software, open and distance learning, e-learning, MOOC, open license and copyright, content management software, library management software, digital library software, community information service and systems, information and communication technology, open harvesting system, open journal system. She has published a good number of research articles, self-learning materials in national and international platforms, and is a member of Curriculum Development Committee. She can be reached at bornali.chakraborty@gmail.com. That is her email ID. Now I would request library section to continue the program.
Thank you, sir. Now I would like to invite Dr. Shankar Gangopadhyay, Director Research, Brainware University, to put some light on the Brainware University, the host Brainware group.
First of all, I would like to say whether I am audible or not. Am I audible?
Yes, sir, you are audible.
Yes, sir.
Audible. So, at the very outset, I extend my heartfelt thanks to all concerned who have organized such a nice seminar. Uh, Special thanks are due to Sujan, who has been instrumental in organizing this seminar. And moreover, I am thankful to the learned speaker who is supposed to enrich all the participants with her expertise in this particular field. I am also thankful to all the participants who have come here to enrich their knowledge through this webinar. It's relevant to mention in this connection the in COVID-19 period, the whole scenario of catering education has changed dramatically. You know, in place of physical interaction through internet has started. And in that way, there are some merits associated with that. Because sitting at home, you can enrich yourself through the webinars launched by eminent personalities of premier institutions like IITs and even the premier institution abroad. But in this connection, it also deserves mentioning that the platform required for having access to this teaching learning mechanism is not available to a huge section of our country. So I look forward to the days when the necessary platform of having this knowledge through this internet mechanism will be accessible to them. You know, days are not far up because we have switched over to a new form education over here. So this is all about the merits I'm talking about through internet education in the COVID-16 period. I'm not talking about COVID-19 period. I'm not talking about post-COVID-19 period. I'm talking about, co-COVID-19 period in the sense because we do not know how long it will sustain its activity. Uh, Meanwhile, without lengthening my discussion, I would like to mention something about the university or institute to which we belong. Brainware Group of Institutions started its journey in the year 2009-2010 under the dynamic leadership of founder Mr. Falguni Mukherjee. You know, to start with, SBET Brainware Group of Institutions cater to teaching learning process in some engineering disciplines, namely mechanical, electrical, computer science engineering, electronics and communication engineering, etc., etc. But Mr. Falguni Mukherjee is a dynamic personality. He cannot rest content with what he has founded so far. So in 2016, another wing was added to the Brainware Group of Institutions. And this is how, Brainware University emerged. So in Brainware University, there are many disciplines that are being taught. And there are some emerging disciplines of contemporary interest like multimedia, allied health, cyber science technology, pharmaceutical unit, mechanical engineering, electrical engineering, computational science, computer science engineering, electronics and communication engineering, management, law, commerce, etc., etc. There are facilities for diploma courses, graduation courses, post-graduation courses, even PhD courses. And finally, what I do like to say that it is in the budding stage. Still, it has been capable of attracting the central interest. New Togo logo has been attached to it from DST, and it has also been granted several projects under the auspices of DST, etc., etc. So the journey has started. The momentum has been generated. I do hope that with the passage of time, the momentum will be enhanced. I forgot to mention another important wing that has been added to Brainware group of institution nearly 2 years back. That is the skill part. That is a very, very emerging area where people of not so high education are made employable through skillful training. So this is all about the thing what I like to say. I wish success for this webinar, and I do think that uh, the particular thing which is being talked about will be addressed quite professionally, and that is quite expected from his stature, from a personality like our speaker today. And particularly, I am interested about one important thing which the speaker is requested to highlight is that whenever we happen to publish any article, be it in book or any journal, etc., etc., the question of copyright involves. So the salient features of copyright needs to be surfaced very, very transparently. Because I have got that experience that whenever I have published paper in journals of repute, there are many book publishers who have requested me to get the article published in book chapters. To me it appears that happens to be a conflict of interest. So in that way, I have not dared to publish those articles in the in the form of book chapters. So I do think I may be a quite I may be quite ignorant of the salient features. So the salient features need to be communicated so that people like us who are not conversant with the methodology and the norms associated with the copyright can be engaged adequately, so that we are not put in the dark when things like what has happened to me may also happen to others. Thank you very much. Wish once again success for this webinar. With this I conclude. Thank you very much.
Thank you, Provisi sir, and thank you, Shankar sir. Uh, Nowadays, the copyright issues is the big issues for our library professionals because the pandemic situation, um, digitized documents share is the big issues for us. So, Gornali madam will share with us her thought. So, please, Gornali madam, you can start your presentation. Madam, please, you can start your presentation.
Okay. Yes, please, please, please. Thank you. Thank you, Dr. Basu, for giving me this opportunity. At first, I would like to convey my heartiest greetings to the August participants present in this webinar, and also like to extend my heartfelt thanks to the organizer for offering me such opportunity to extend my views on topic digitization and copyright in this global platform. I'm really thankful to the higher authorities, vice chancellors, librarian, registrar sir, pro-vice chancellor sir, assistant librarian of Brainware University. Thank you very much. And now I think I would like to start my topic with my views in this platform. Actually, today we are just going to have a look on the provisions of copyright in case of digitizing our content in library perspective as well as in archival perspective. Some reasons are behind all these things actually playing a pivotal role. So, advent of the information communication technology and World Wide Web, gearing up the transmission is always nowadays actually playing a role of catalyst in this digital society also. And libraries and archives are society's primary information providers. In this view, digitization of content or library holdings is a continuing process of improving their services. So, on the face of it, libraries and copyright protection seems to be located at cross purposes. One seeks to freely disseminate literature, and the other seeks to preserve the exclusivity of the same. Exclusively accessible for the bona fide and genuine academic and research purposes by preserving such creative work. So, on the basis of which or in which context we are trying to discuss copyright issues in present context. So, I'm just trying to share my screen so that I can definitely
We have some technical problems. That's why maybe we are not. হ্যাঁ ম্যাম, হ্যাঁ আপনাকে তো দেখা যাচ্ছে না, আপনি আরেকবার কানেক্ট করুন। আচ্ছা, হ্যাঁ। There are some technical problems arises. That's why we have to stop now. We are trying to recover that. Please stay on. হ্যাঁ 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 সেটা শোনা গেছে আচ্ছা
Susan, am I audible?
Yes, ma'am. Yes, ma'am. You're audible.
And my screen is now sharing. I'm sharing my screen now. Is it visible?
No, ma'am.
Not yet, ma'am.
Is it visible now?
Yes, yes, ma'am.
No, ma'am. Now it's visible, ma'am. Now it's visible.
Is it visible?
Audio?
No, it's visible.
Audio
now.
visual are both of okay.
So I'm just starting my topic again. That is what I'm trying to elucidate in this topic. That is, due to advent of information communication technology and World Wide Web, which is actually gearing up the transmission of knowledge in a very robust manner, and COVID-19, which is actually playing like a catalyst in the society. Now, actually, these are the things which are gearing up libraries and archives to promote each and every content in a digitized manner, so that each and everyone can, or its user can access all these things from their home itself. So now the thing is whether the digitization is actually helpful for the libraries itself, whether it is actually protect institutions from the possible litigation, where it has provided impossible to identify the copyright holder, or it is recommended that access to the digital collection is reliant upon acknowledgement of the copyright disclaimer, like that. Such kind of issues are going to be covered through this presentation and through this discussion. So at first, with the short intro of this information communication technologies advent and World Wide Web advent, I would like to switch my focus on first the issue of digitization. And in this relation, I will discuss on the issue of copyright. So first, what is digitization? So I'm taking this paragraph from the Biplab project, one kind of guidelines for digitization project is there. So there, Biplab told us that digitization is the creation of digital objects from physical, analog, or originals by means of a scanner, camera, or other electronic device. And the entire process may include selection, assessment, prioritization.
She's not audible.
Metadata collection and creation, like things are like that. So in that case, we have to definitely look upon the digitization process as well as the entire thing of digitization, because digitization is nothing but a conversion of tangible or analog content to digital or electronic content. So this is the thing, this is the main issue of the word digitization or the process of digitization. So now the main thing is that why we will go for this digitization process. So digitization process, first of all, main necessity of this digitization process is to increase access. First of all, to increase access. Then, preservation of the document. Preservation of the document and ensuring reusability of the document. And the fourth one, to develop collaborative resources sharing with other institutions via or through a virtual platform or through a virtual collection. So these are the main cause behind the digitization of a library material. Actually, digitization doesn't change the content. There is a difference between content and conduit. So content is the entire thing which is actually created by the content contributor, by the author, by the performer, or the visual art creator, like that. And conduit, just like we were using, and even nowadays also we are using paper material. In previous days, people are using clay tablets like things, and now we are using computer or our computer screen, our laptop screen, our mobile screen. So these are the conduit through which we are accessing the entire content. So information communication technology actually changing the conduit, not the content. And we are actually discussing on the copyright, which is actually related to the content and the content contributors' right. So digitization is required to increase access of the content, to preserve document, which is also a content, ensuring reusability of the document, which is also a content. So these are the way we are increasing access, preserving, and reuse or remix all this content in a global platform. This is the main motto of digitization. So one thing is this, that each and every library should consider factors before digitization. So what are the factors? What factors actually we are trying to consider before digitization of each and every content of the library? How much of the protected work may be taken, or did they make a copy of just a paragraph, or did they make copy of the entire book by following copyright or not, like something like this. So these are the confusing matter for every library, for every institution, but still we are in the process to digitize our content for the ease of accessibility. So library should consider such kind of factors like policy of the institution, whether the institution opt a policy or pause a policy or frame a policy for the digitization, whether the institution is ready to spend money or spend financial resources, whether it's the institution's manpower is ready to adopt this or to circulate this, its technical capability and the legality of the digitization under the copyright law of each country. So each and every factor of this slide, like policy of institution, financial resources, manpower, or technical capability, actually depends on the institution itself. But the legality of digitization, which comes under the copyright law of each country, actually this is the main thing, and this is the most valuable thing to digitize our material. So now, whenever we are actually talking about the copyright and all, so copyright law, before starting this slide or before starting talking about anything on copyright, I just want to tell few words. That is, copyright law and digitization of library resources actually clearly poses significant issue to the digitization of library resources. And various studies shows that copyright law impacted on the practice of digitization and the options available to libraries to carry out digitization activities without infringing copyright. So, copyright is actually a valuable issue, and it's an important issue to look upon. So let's have a look what is exactly copyright is, because we have different kind of copyright laws in the present situation. One is for international copyright law. We all know about World Intellectual Copyright Law. We know about Indian copyright law. We know about US copyright law. So there are several kind of copyright laws there. So as per WIPO, that is World Intellectual Property Organization, copyright is a legal term and which used to describe the rights that creators have over their literary and artistic work. So all works actually covered by the copyright range from books, music, paintings, sculptures, film, computer programs, database, advertisement, maps, and technical drawings. So these are the things actually comes under the umbrella term of copyright, right from the book to technical drawings. And we all have to consider all these things under the digitization process. And this, in Indian context, in Indian copyright law is just, it's elucidated as copyright is a bundle of rights together with rights of reproduction, communication to the public, adaptation, and translation of the work. So it's one kind of, actually Indian copyright law, actually they're specified by the law to creators of original literary, dramatic, musical, and artistic work, and producers of cinematograph, films, and sound recording. So these are the actual framing of the copyright, which kind of things or which kind of creative work actually comes under the umbrella term of the copyright. So this is the actual interpretation of the from the desk of law. So these are the international copyright treaties and agreements for your information. So we have WIPO Internet Treaties, WIPO Copyright Treaty, and the more important are Berne Convention, Geneva Phonogram Convention, Universal Copyright Convention, Brussels Satellite Convention, like that. So on the basis of this kind of treaties and agreements, copyright is actually nowadays copyright actually got its stable platform for each and every country. So in Indian perspective, Berne Convention, Universal Copyright Convention, WIPO Copyright Treaty, and WIPO Performance and Phonograms Treaty actually govern the Indian copyright law. So now the main thing, so which kind of rights we are actually right from the beginning of this webinar, I'm talking about the copyright. So which kind of right retained by this Copyright Act, we have to know first. I told you that there are different creative works in the field of Copyright Act or under the umbrella term of Copyright Act, like literary, dramatic, musical work, or artistic work, or cinematograph, like that. So in case of literary, dramatic, and musical work, and not being a computer program, what are the rights actually retained by the Copyright Act? First one, to reproduce the work in any material from, including the storing of it in any medium by electronic means. First. So reproduce the work, it is actually banned by the Copyright Act. Then why we will go for the digitization? Second, to issue copies of the work to the public, not being copies already in circulation. So it means not for any retrieval purpose. If you have any kind of material which is actually in electronic means, or it is a reproduced material, then it is not for retrieval purpose. To perform the work in public or communicate it to the public. To make any cinematograph, film, or sound recording in respect of the work. To make any translation of the work. Just see, each and every right, actually, each and every kind of reusing capacity is restricting by the Copyright Act. Next, to make any adaptation of the work. So we can't do any derivative work through this copyright under this Copyright Act. In relation to a translation or an adaptation of the work, any of the acts specified in relation to the work in subclauses 1 to 4, and in case of computer program, that to do any of the acts specified in clause A, like such kind of 1 to 7. So we can't do anything with the computer program like clause A, like to reproduce the work, to issue copies of the work, to perform the work in public, or to make any translation, to make any adaptation, or in relation to translation or adaptation of the work. We can't do anything in case of computer program also, apart from that, to do any of the acts specified in clause, to sell or give on commercial rental, or offer for sale or for commercial rental. It means it is restricting the commercial terms or commercial handling. So these are the rights actually retained. I would like to prefer the word restricted by the Copyright Act, because it is actually violating the main plethora of education, that is access to information for all, isn't it? We are actually actually violating such kind of things by the Copyright Act. So how digitization of a library context or a archiving context is possible in this view? So, and even in case of copyright, which means the exclusive right subject to the provision of this act to do or authorize the doing of any of the following acts in respect of a work of any substantial part of thereof. So these are the things actually we are looking for. Which kind of restriction we have with the Copyright Act? So this kind of restrictions we have. It is also same in case of artistic work or cinematograph. As because we are the library professional and we are from the library and information science profession, so we are generally trying to do with the literary and dramatic work and musical work. So that's why I'm giving less focus on the cinematograph or any sound recording or artistic art like that. So now in Indian Copyright Act 1957. So what are the time period of copyright protection? So we have to know all these things, because first of all, we have to know the time limit. We have our information on the different kind of rights, and now we have the information of the time period about that rights. Suppose in case of literary, dramatic, musical, or artistic work, as per Indian copyright law, it is lifetime of the author plus 60 years from the beginning of the calendar year next following the year in which author dies. So lifetime of the author plus 60 years from the calendar year in which the author dies for this literary, dramatic, musical, and artistic work. And from the other work like anonymous or pseudonymous work, posthumous work, or cinematograph, sound recording, something like that, or the public undertaking, international agencies. For this kind of creative work, we have 60 years of restriction, which begins from the calendar year next following the year in which the work is first published. So one is for literary, dramatic, musical, and artistic work. lifetime of the author plus 60 years in which the author dies, and for other works like anonymous, pseudonymous, or posthumous work or cinematograph, it is 60 years right from the first publication of that particular work. So these are the time period. We actually we have that information. So which kind of restriction we have and for how long. Then if such kind of restriction is there, then why we are bothering for this copyright and all? So this is our question. So in that case, I'd like to prefer this word, that the protection provided by the Copyright Act to the hard work of the content contributors really is their brainchild. Each and every content and each and every work is a brainchild of the content contributor. Who are the content contributors? Writers, artists, designers, dramatists, musicians, architects, anyone who are actually producing the original work. So these are their brainchild and they opt it from their hard work. So they create an atmosphere of contributing to knowledge society. And copyright motivates them to generate more quality product for their future. Isn't it? Actually, we are really preferring our name, our fame, isn't it? So copyright actually retaining our right that it is mine. And or content contributor, they are actually on in such a issue, they are actually self-motivated in the terms that this is our work or this is my work. So it is actually retaining content contributor rights in economical term, in societal term, and in moral term. So that's why copyright is needed. So rights of the right owner, which kind of rights are there for the right owner? So we have information regarding restriction of the copyright. We have information regarding the time period. We have information about the necessity or requirement of the copyright. Now, what are the rights of the right owner for whom actually copyright is restricting or retaining? So first of all, for economic rights. Each and every content contributor has their economic rights. Economic rights to exploit their work, for example, to opt monetary benefit in terms of sale or copy their creative work. So they are actually benefiting themselves in terms of money. So not only name, not only fame, there is money also. For why? Copyright is retaining rights of the right owner. Second, moral thing, which is actually very important, even much more important than economic rights for the academic world, isn't it? For moral right, actually, it's to be named as the content creator or to object to change. Actually, author or the content creator, he or she might be the boss of his or her own, who can actually offering permission to the user in which way they can use their content. This is the moral right. And lastly, legal right. To retain all rights for offer permission to user to use, copy, and augment. Whether it is a usable, reusable, whether it is a remixable, whether it is a redistributable, like that, or whether it is a editable work or not, it will be definitely defined by the content contributor. So these are the rights of the right owner, actually. So that's because of why copyright is very much necessary in this academic world. Just think about the previous, at the ancient age. On that time, one person, one content contributor is preparing a document for the years and years. And some other person is copying this manually. It also takes for years to years. And after the invention of the printing machine, copying is very much easy. And that's why the loss of in a huge manner. The different kinds of content are being copied in a huge manner to restrict such kind of illegal job or to restrict some kind of practices. Copyright is there. And the main thing is to restrain or restrict the economic rights, moral rights, and legal rights of the right owner. So, what are the challenges in this case? Challenges to digitize content in libraries. What are the challenges actually in such a way? So, reproduction in various forms, which is actually trying to replicate the term digitization. It is impossible. The distribution of the copies, it means retrieval of the same document or digitized document is actually restricting by the copyright law. Public performance via computer, it is also the restriction of the law. And translation into other languages or adaptation like digitization or importation of infringing copies, such kind of things are really challenges to digitized contents in libraries. So these are the challenges for academic world as well as for the libraries. And I'm talking about actually in Indian perspective I'm talking about, but for the entire world, the skeleton is the same. Just there are difference between the time period. There are difference between the fair use and fair deal, like something like that. But the entire thing is like that. The entire skeleton and the main part is that copyright actually restricts reproduction in various forms, distribution of copies, public performance, broadcast, or any other communication to the public, translation, adaptation, or importation. Such kind of things are really restricted by the Copyright Act. So, what will library do? This is the main thing. So, and for that, it is actually what I am talking about. That challenges. These are the actually comes under the infringement of copyright, which is really a legal offense. Infringement of copyright is really a legal offense. So there are remedies also for this copyright infringement. Civil remedies are there. Content contributor would be able to claim for injunction, damages, or accounts of profit. And criminal remedies, there is also criminal remedies that infringers shall be punished for the term not less than 6 months. Mind it is for Indian context. This civil remedy and criminal remedies. Civil remedies are quite same for the international copyright law, and for criminal law remedies, it is for Indian perspective that infringers shall be punished for the term not less than 6 months, which may extend to 6 years, and also she or he might be actually charged to pay a fine not less than 50,000 rupees, which may extend to 2 lakh rupees. Just think about the punishment. And what we are doing in our practice, that is copy paste and all. Actually, all these things comes under the copyright infringement. Even if we copy our own work from one published work to another work without any acknowledgement, then it will be auto plagiarism. It is also violation of the copyright. It is also copyright infringement. We can't even utter a single word without acknowledgement. Definitely there must be an acknowledgement for the actual or original content contributor. This is the main thing of the copyright. So we have information regarding civil remedies and criminal remedies. Now, there must be definitely there must be some way out for the entire thing. There must be some exception. There must be some loops so that we can go further. So even here, one thing is actually we have to know one thing, that copyright is work which is considered as infringement only if a substantial part is made use of unauthorizedly. This substantial word actually varies from case to case. Sometimes it is two or three paragraphs, or sometimes if a content contributor copy a very catching phrase or paraphrase from any authors or any another content contributor's work, there is likely to be infringement, even if that phrase is very short. Just in our recent days, we gone through one experience. That is one popular song sang by Badshah, a well-known singer, and he took one catchy line from our singer of from Birbhum district, and she even not utter a single word for the acknowledgement of him. So in that case, that is also comes under the copyright infringement. Even if in this webinar someone is taking screenshot of the entire slide without seeking any permission from the organizer or from the presenter, then it will be a copyright infringement. So this substantive word, it is varies from case to case. Sometimes it is 2 or 3 paragraph or more than 5 to 6 page, or sometimes it is just only a important phrase or paraphrase like that. So we have to be very cautious regarding this Copyright Act or law, and most of the copyright laws state that that the author of the or right owner has the right to authorize or prevent certain acts in relation to the work, and the right owner of a work can prohibit or authorize such kind of things. So there must be some exceptions or excluding options in in each and every Copyright Act. So in Indian perspective or in a world perspective also, some topics or some points there exist in the Copyright Act for the excluding. So first one is for the purpose of research and private study. So just see, in previous slide we are talking about the not to reproduce the work, and here we have a loop, that is we can use any copyrighted material for the purpose of research or private study. We can use such kind of copyrighted work for criticism or review, for reporting current events in connection with any judicial proceedings, performance by an amateur club or society, which is actually given to a non-paying audience, and making of sound recordings of literary, dramatic, or musical works under certain conditions. So these are the generic exclusion of the points which actually is not a copyright infringement in general. And it is also same in case of foreign publication also, in foreign policy also, even in case of international copyright also. And in in our copyright law in Indian perspective, we have fair use exceptions in academic sector, including libraries, which is actually really important things to digitize or to be in the process of digitization of the library or archive. So what are these? This comes under the section 52(1), and it is actually not in the previous Indian Copyright Act of 1957. It is a new amendment of which is occurred in 2012, which comes under section 52(1). Under section 52(1), one is there, I, that act is I, that reproduction of any work by a teacher or a pupil in the course of instruction is considered as fair use. So here we can do this. What is that? Reproduction is possible of any work by a teacher or a pupil in course of instruction. Then in under section 52(1), there is a point N, that is the storing of a work in any medium by electronic means by a non-commercial public library for preservation if the library already possesses a non-digital copy of the work. So if you have any hard copy, your library possesses a hard copy of the hard copy of a copyrighted book. So that library is in a position to make an electronic copy, and it is for non-commercial public library only. And under P, that is 52, section 52(1), P, that is before that O is there. The making of not more than 3 copies of book, which includes pamphlet, sheet of music, maps, charts, and plans by or under the direction of the person in charge of a non-commercial public library for the use of the library if such book is not available for sale in India. If a book is not available for sale in India, then making of not more than 3 copies of the book is actually, it is not under the copyright infringement. Another point uttered as in Copyright Act 1957, which is amended in 2012, that the reproduction for the purpose of research or private study or with a view of publication of an unpublished literary, dramatic, and musical work kept in the library, museum, or other institution which has the public access. ZB, which is much more important in this time, as per my view, that the adaptation, reproduction, issues of copies or communication to the public of any work in any accessible format by, number 1, any person to facilitate persons with disabilities to access to work, including sharing and with in an accessible format for private or personal use or educational purpose or research purpose. So adaptation, reproduction, and issue of copies is actually not in a copyright infringement if it is meant for the persons with disabilities of an institution. 2, part 2 under ZB, that any organization working for the benefit of the person with disabilities in case the normal format prevents the enjoyment of such work by such persons, provided that the copies of the work in such accessible format are made available to the persons with disabilities on a non-profit basis. So non-commercial thing is very much important for the fair use or exceptional work which comes under the copyrighted work. So these are the actually exceptions which is not a copyright infringement and which is actually articulated in Copyright Act, Indian Copyright Act, as well as it is articulated in the World Copyright Act, and actually it is following by the US Copyright Act, etc. So, but in this case, many foreign publishers are not ready to recognize the right of the visually impaired person even till the date, unfortunately. But I hope that they will definitely do the same job like such kind of things. So whereas even here I have a point that whereas the section 52 gives some exception to do digitization in library section, in libraries, in such a way, section 65 actually it is conflict with the section 52. Section 52 conflicts with the section 65A, which entitled as protection against circumvention of technological measures. And under this provision, Any person who circumvent an effective technological measure applied for the purpose of protecting any of the rights conferred by the Act with the intention of infringing such rights shall be punishable with imprisonment, which may extend to 2 years and shall be liable to fine. So it means this act become punishable although it is allowed as per fair use exception under section 52. So I'm a little bit confused with this section 65A act with the section 52. Section 52 is actually in favor of the libraries, in favor of the academic sector, in favor of the knowledge society, whereas 65A actually conflicting all these things. And nowadays, digital content are actually available in the world in various ways. But digital content, it is actually easy to copy, easy to share. But here also, the publisher actually encrypted this kind of content with the Digital Rights Management Act, which can be restricted by the publisher as per the terms of the license. So here is also a restriction. So whereas we have 52 laws in our hand as a preferable platform, then 65A and digital rights management, it is actually creating barrier to do all these things. And IFLA has its own views on these copyright issues for libraries. What IFLA actually articulate in his copyright issue for libraries, which is actually available in the IFLA's page, that copyright is neither eternal or universal, because we all actually know that each and every copyright holder has its own time period. There are also legal flexibilities in copyright known as limitation and exceptions, which are intended to promote access to and use of our work. So in this platform, much attention is really need to be paid to the academic and research library who are involving to dissemination of information. So this is actually IFLA's thought and IFLA's views. So we have a win-win situation, that we have copyright laws and we have exceptional laws under section 52, which are not the infringement of copyrights. And in that case, we can literally, by following those kind of acts, we can digitize our library content. But it is also a restricted provision. Is it quite comfortable thing in between the restriction? So to get rid of such kind of things, so get rid of this copyrighted issue for the digitization process, for the digitization workflow, what a library can do. First of all, a library can or able to digitize maximum documents which are available in the public domain. So public domains means those materials which doesn't cause any copyright law, which is not under the copyright law protection, number one. Number two, those materials or content of which copyright has expired, for those materials or content of which copyright owner failed to follow copyright renewal rules, and the copyright owner deliberately places in it the public domain known as dedication. So such kind of provision actually comes under the public domain. So we can use those content which are actually available in the public domain for digitization process. Lots of resources are available. And after that, we can follow those documents, those contents which comes under the open license system. So what is actually open license? Well, open license, it is actually a provision which is giving us a prior permission to use, to reuse, to remix, revise, and restrain. There are two kinds of open licensing system in our present situation. One is Creative Commons license for artistic and literary work, and another one is Science Common, which is actually dedicated for the science region. So Creative Commons, which is actually a non-profit organization and which actually offer us 6 kind of licenses or license elements for the content. Actually, with this license, what a content contributor can do or a right holders can do, that they can priorly give the license how to use, how to reuse, how to remix, how to revise, or how to retain the entire content, and even how to redistribute to entire content. Just see, I'm talking about re. It means key. It means that the first original work, then we can augment it further. So 5 R's are there: reuse, remix, repurpose, like that. So these 6 kind of licenses, these 6 provisions actually giving users the permission how to use the content. And first one is, that is Creative Commons. CC is for, just look at the pictures. These are the logos of the licensing system. That is CC BY. First one is attribution. It means credit the author. Creative Commons and open license, that is not copy left. That is not the other thing. It is actually giving you the prior permission that you can use use this kind of content in such a way. But one condition is there, that you must have to acknowledge the original creator. So this is the one thing. There is no economic barrier, there is no technical barrier, there is no social barrier to use it. There is no infringement of copyright. Just you have to acknowledge the original author. This is the main condition of the open license. So Creative Commons is a non-profit organization. They're giving you provision or giving a content contributor that provision, then you can share your work in such a manner. First of all, attribution, that gives the credit to the author and use it in any way. Second, you can use this document, which is actually called as attribution share alike. Share alike means you can reuse, remix, repurpose this kind of content, but you have to redistribute, or you have to use this document or your new work under the same license, that is share alike. After that, attribution non-commercial, you can use, reuse all this thing, all the content, but you can't make money by using this content. Then attribution non-commercial share alike, it means you can use, reuse, remix all the entire the content, but you can't use in any commercial purpose of that content. And the last one is non-derivative. Non-derivative means you can use, but you can't make a new work by using that particular content. That is non-derivative. And attribution non-commercial, non-derivative is the most restricted provision of Creative Commons. Actually, it is restricting your derivative work, as well as it is not giving you permission to make money. So these are the things actually we have to look after. And under this license, any content can be digitized in libraries or in academic purpose, and even in any term of use. And so these are the rights. What are the rights? Reuse, revise. I am talking about the reuse, revise, remix, redistribute, and retain. So reuse means use the content in its unaltered form. You can use it in any way. Revise, it is adapt, adjust, modify, improve, or alter the content. Remix give you the permission to combine the original or revised content with other open educational resources to create something new. So just see about the rights actually they are offering to you, content contributor or the right holder offering to the user, any kind of augmentation, any kind of editing is possible in this case. Even you can redistribute, means share copies of the original content, revision or remixes with others. And lastly, you can keep access to the material after the learning event. So these are the rights, actually, these are the flexibilities using by the open licensing system. So by this six licenses, you can do anything. And lastly, the Science Commons. Science Commons actually, it is actually the project under Creative Commons with the goal of briefing the openness of sharing in scientific discovery, innovation, and collaboration. So it is also the same. It comes under the open licensing system. So there are lots of impetus we can do with the we can do our digitization process with the help of the provision which comes under Act 52, as well as we can much more comfortably do or digitize copies of the entire book or and the entire content which comes under the open licensing system and which comes under the public domain. So in such a way, we can really digitize our entire library system or entire thing. Otherwise, it is really a hard time for the libraries to cope up with the or to protect institution from the possible litigations or of the copyright holder. Sometimes actually we are not even aware of the copyright holders' name, their institutions, their um, parent organizations, so that we can seek permission from them to digitize the entire content. So it is really a challenging thing for the libraries, and it is really not possible in case of mass digitization. So these are the things actually, and I hope that the study of this of the more impetus of the digitization and copyright actually satisfy your queries. And at the last, I can say that more possibilities which are actually made for the public libraries, academic libraries, special libraries actually need it much more impetus for each and every country for the knowledge base, for the dissemination of the knowledge, for India and for the entire world also, because we don't have really that much of exclusive act to digitize the entire content of the library. And now the demand of the time is to digitize all this content for the preservation purpose, for the access of the increasing access, and for the sharing or collaborative platform, so that we can disseminate knowledge as much as possible. And at the last, I hope that the study really satisfy your queries with the related to the copyright issues and that arise from the digitization and the principle of copyright law that govern digitization, and library can act as per. So thank you very much for your patience. And if you have any question, so please convey it to me so that I can I will try to satisfy your question.
Madam, I have got one question to ask you. Okay, can you hear me? Am I audible?
Yes, please. Yes, you are audible. Please.
Yeah. Normally,
Yes,
what
sir, you are
happens
audible,
is, what you are talking about, the copyright is something lying with the, the author. But what happens for any international publication in any journal whatsoever, you will have to transfer the entire copyright to the journal authorities. So
Yes.
in that way,
Yes, sir.
you have got no right to claim his copyright anymore as the author. So
Yes, sir.
this is the question. I put forward before you in my address.
Yes.
Because
Yes.
I have got many publications in international journals of repute, and some book publisher demanded that those things should be taken as book chapters So I did not dare to, publish those articles in the form of book chapters, because that will be creating a conflict of interest. Was I correct in that effort? Because the copyright does not lie with the author. Copyright is entirely transferred to the journal authorities. Unless the copyright is transferred to the journal authorities, they are not supposed to publish your article. Am I clear? Hello?
Yes, sir.
Am I clear?
Actually, yes, yes, sir. Am I audible? Am I audible?
Yeah.
Yes.
Yeah.
Yes, sir. Actually, this is the present practice of, it is not the journal publisher, it is the entire publisher. And just because of why the provision of open licenses is there, because the publisher, maybe it's a journal publisher or maybe it's a book publisher, whatever it may be, they're actually doing their monetary profit. They're actually gaining monetary profit with the work of the author. So even you are rightly pointed out that copyright is not the actual bread and butter of the author or the content contributor or the original contributor. It is the actually it is the bread and butter of the publishers who are actually doing some contract with the copyright or with the author to change to obtain their rights. So we are even, I am also signing all kind of contract for the foreign publisher to publish my article, isn't it? So in that case,
the copyright is transferred thereof.
Yes, it's transferred. So one thing is there. So here conflicting of copyrights is there. So author addenda is there. Author addenda, if we are trying to sign a copy through which we can, or we are proposing them that one copy of the original work is to be, actually there is a embargo period of 6 months for various journals, isn't it? For 6 months of embargo period. After 6 months, each and every university or the parent university of the author can opt that particular content or particular article. So there is a provision.
Regarding book chapter.
Yes.
Regarding book chapter, what is the embargo?
Regarding book chapter, even no, there is actually for book chapter also 6 months time period is the embargo period in general. In some cases, it may vary from journal to journal, from publisher to publisher. It may extend up to 2 years also. Then after 2 years, you can open it for your institution, isn't it? There are various provisions.
I am actually talking about IEEE publication or Optical Society of America publication.
I can understand. I can understand, sir. I am also actually I am also going through the same issue, and in that case, you can propose them that in institutional repository, you can use one of that particular article. You can use master copy or preprint of the master copy of that particular journal article. So there is a provision. But whenever we are talking about the publisher, they're actually doing monopoly in this case, and that's why
that I'm not talking about. Can it be published in the form of a book chapter? Certainly not. I do think.
You have to you have to edit it. You have to edit it first. The same content is not allowed to publish. No, the same content is not allowed to publish in 2 places, whether it is article form, whether it is in book form. It is auto infringement. I told you, sir.
That I'm not talking about. That I'm not talking about. They want they want the thing in the form as such. So we cannot edit that, because there are mathematical things, etc., how we are supposed to edit all these things. Anyway, what has
under the same publisher, under the same publication house?
No. Say, for example, I have got one IEEE publication, and some book publisher is wanting to get it published in the form of a book chapter in their book. So normally it appears that I am not authorized to make it a book chapter because I have transferred the copyright to the journal publisher already. So, there should be conflict of interest. This is what I'm talking about. I'm talking about, is there any embargo for this thing? Yeah, after 10 months or 2 years, it can be done. Am I clear?
I think Madam, no, Madam is disconnected, I think, due to the network problem. We are
Okay.
trying to reach her. Please hold on.
And I can see you all, including Bandana Basu, Tumi, Shanku, Bandhu, sir. Is it visible?
That's right. Madam, bolun.
Yes, yes. Okay.
Yeah? Okay.
Yes, please, sir.
Yeah, my question is very clear.
Hmm.
My question is this: I have transferred the copyright in the form of publication in one reputed journal. Should I be able to publish the same article in the form of a book chapter as the publisher demands as such? Normally, I feel I'm not authorized to do this thing. If I'm authorized, what sort of embargo I will have to face?
No, you are not able to do that. You are not allowed to do that. Even the publisher is not allowed to do the same.
Okay. But they are claiming that it can be done. It can be done.
No.
Tata Magru is talking like that. Tata Magru is talking like that. They are telling that we are capable of doing this thing. We need not worry at all, because there is an important article published in Elsevier. They are telling it is publishable. You need not worry about what you have done in the form of copyright transfer to the journal authorities. So
I don't think so. It is
I am not allowed
It is not possible.
If I'm put at this age in the form of copyright violation, producing conflict of interest, then things will not appear rosy for me. Am I clear?
Yes. But it is not.
So your assessment is that it is not allowable, isn't it?
No. Please don't do that.
Okay. I have not
Thank
done.
you.
I am wanting if there is some green light on this thing in the form of embargo or something like that.
You are right, sir.
You
were right.
No, not at all. But what happens is this: the copyright is not the butter of the author. The copyright is the butter of the publisher. Absolutely. The tragedy lies there.
Yes.
Am I clear?
Yes,
Am I
sir.
audible, madam? Yeah.
Yes, you are audible.
I've got no other question to ask. Another thing is this: there are many publications which can be downloaded from Science Direct. Is library authorized to maintain those things? There are many publications which require subscription for access. But normally, if you go to Science Direct, you can download those articles. And by downloading those articles, if you preserve this in the library, will that create any legal problem?
No, actually, it is under open access content. Some open access, some content, some articles which are available in the open access platform.
I'm not talking about open access. I'm not talking about open access. If you go to Science Direct, you can have access to any journal whatsoever.
Yes.
You can have access to any journal. Normally, you are not supposed to have access unless you put subscription for those things. So in that case, is library authorized to preserve them?
Yes, sir. Its full text is available and it comes under the open access platform. That's why library is able to preserve
it is not an open access. It is not an open access. You go to Science Direct, you can, you can download any subscribe journal whatsoever. So, subscribe paper of any journal. Normally, you will see this will require so much dollar, so much dollar. You can download all these articles. Am I clear?
If it is freely downloadable, if it is, so two things is there. One, it is, if it is freely downloadable in full text form,
it is not freely downloadable. It is
then
not
you can't do this. Then you can't do the same thing for retrieval purpose, but you can use that article in your library itself. It is bounded
because
with the
it is
institution
a non-commercial
only.
organization, isn't it? Because it is a non-commercial organization, these articles can be preserved in the library. Is it like that? Am I audible? Yeah. Because it is a non-commercial.
Yes, you are audible and you are right.
Thank you very much for your nice and lucid description of the matter.
Thank you, sir.
Thank you, sir. Thank you, ma'am. Ma'am, there are some questions in your private chat box. Kindly go through those questions, ma'am.
Yes. Sujan B. Chakraborty, actually, Sujan, you are actually reposting the questions in my chat box.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
One
The first question was
he is
from
downloading. No, actually, as it was, it is not actually visible from my private chat box. There are only two questions is visible from my private chat box. That is Otonu and Janice. So I'm actually trying to answer their question first. And if possible, please repost all the questions in my private chat box. So first one is downloading of ebooks on open source platform violating the copyright rules? No, actually any content or any article or any educational material which are available from open source platform, downloading the same is not the violation of the copyright rules, because open access or open source gives you prior permission to use, reuse, remix, revise and redistribute it. So it is not the violation of the copyright rules. You can use open source or open access platform for the educational purpose.
Sujan, any other questions?
Yes, Archana Shaw. Actually, she articulated a wonderful question that some points are in pink font and some are in black font. What is the significance? So, significance is actually I am trying to focus on the important phrases of my deliberations. So that's why those fonts are in pink font. Those are the most important part or the main essence of my presentation. What is the disadvantage of copyright? I told you actually it is restricting the provision of access to information thing and dissemination of knowledge. So restriction is there. This is the disadvantage. So it is from Archana. And Chandrika Chatterjee, she told me that freely available documents can be redistributed to others for reading without violating copyright law.
No, ma'am,
I can't understand this question.
Atanu Das asked that freely available documents can. Yeah, Atanu Das asked that freely available documents can be redistributed to others for reading without violating the copyright law.
Oh, acha. So no, actually there is difference between freely available document and open access document. Freely available document are always might not be under the open licensing system. But various kind of documents which are freely available in the web may not be in a part of open licensing system, there may be some issues of copyrighted things, because different kind of journals, they are actually giving us permission to download their article. So it is not comes under the copy left or public domain thing. It might be under the act of copyright law. So it is not like that freely available documents can be redistributed. If it has any kind of open license like CC BY SANC, CC BY or CC BY NCND like this, you can redistribute this. And another question,
The next question
Sujan,
asked by
please help me.
the next question is asked by Mr. Sunil. Circulating PDF of
Yeah,
newspapers in WhatsApp, Telegram groups, etc. is illegal under Copyright Act.
I think so. Actually, as per Indian Copyright Act, or as per the copyright law, world copyright, international copyright law, newspaper or news is not under the, actually not comes under the infringement of Copyright Act, but the circulation of PDF form, that is comes under the violation of copyright law. Actually, copyright is not there of anyone's concept or anyone's title or slogan. Actually, copyright is only applicable for the expression of your thoughts. So whenever expression of thoughts is in PDF form, so it is violation of copyright. Next.
Next question, ma'am, asked by Louisa. If I am remember correctly, only 5% of our legal library material can be reproduced,
Library
right?
minute. Yes, which comes under the copyright law. Only 5% of the entire library holdings, actually entire library holdings, it is only 5% which is under the Copyright Act, and it may be reproduced without infringing any copyright law. But whenever we are talking about the much more circulation, we are talking about the widening its accessibility. So we have to look upon the digitization of the entire library content, or maximum number of contents which are available in the library. So in that case, section 52(1) is the exceptions, and under the open license materials and under the public domain documents, we can digitize it within the library perspective. This is the thing.
Momita Mitra asks,
Thank
if
you.
author's information is insufficient, then how can we get the author's permission if some pictures, graphs, quotes is required for fair use, like for educational purposes or research?
Will you please repose the question again? Please repose
Yes, ma'am.
the question again.
The question is, if author's information is insufficient, then how can we get the author's permission if some pictures, graph, quotes is required for fair use, like for educational purpose or research, etc.? Asked by Momita Mitra.
Yes, actually, I told you that in my deliberation that if author is not available, or if author's information is not available in the content or in the book, so it is really hard to seek permission, as I told you in my presentation. In that case, we can acknowledge him. We can acknowledge, or we can use that particular document by acknowledging his or her work. This is the thing. And we are not reproducing the entire work. We are taking just part of his or her work. So for using part of any author's work is for the educational purpose is not copyright infringement. One condition is there, you have to acknowledge the author, acknowledge the original work.
Okay, ma'am. Jishnu Bhattacharya asked, does use of e-text used exclusively for academic purposes come under the purview of copyright?
Yes, please. Actually, it is not clearly audible to me. Please post, copy and paste this question to my private chat box so that I can understand the
Okay, ma'am.
question.
Can you hear me, ma'am?
Yes. Jishnu
Jishnu
Bhattacharya, does
Bhattacharya
use of
asked,
e-text
yes.
Does use of e-text used exclusively for academic purposes comes under the purview of copyright? Actually, that the same answer is there. If that text, whether it is e-text or whether it is text in print format, whether it is print format or whether it is in online digital format, that doesn't matter. Main matter is the content. If content is copyrighted or comes under the Copyright Act, we can use it for the academic purpose only, for the private use or for the research work only, but we can't circulate this work for further use. Next.
Ma'am, next asked by Jensi Zuban, that is downloading of ebook
I have
for
already
research. Okay.
I have already answered this question.
Okay, ma'am. Then the next question is from Shekhar Modak. If possible, it's possible or not for preservation of article for the digital repository from Web of Science or gesture, etc. I think you have answered this one also. Sir asked you about this, I think.
Yes.
Then Devdeep Chaudhary, if a non-profit educational organization sharing e-resources for study and learning purposes, which already available on internet in their social media pages, is it a violation of copyright or not?
No, actually, same answer. If it is comes under whether it is available on the online internet or not, that doesn't matter. If it has copyright law or copyright act or copyright symbol, then it comes under the Copyright Act, and circulation of the same is violation of copyright. If it comes under the open licensing system, it is permission is already given to you to reuse the same, and you can circulate the same, and it is not comes under the copyright infringement. Thing is very much clear.
Okay. Some of the participants asked that how do you know which is under copyright and which is not?
It is already symbolized by the copyright logo and with the open licensing logo. If there is any copyright, it comes under copyright, then copyright logo of the copyright is there, and the name of the copyright holder is there. And if it comes under the open licensing system, then CC BY SA or CC BY NC SA or CC BY is there. So logo is there. Declaration is there in the works of title page.
Okay, Mr. Shamor Kumar Das asked, how can I get in touch with the copyright owner of any work?
How can I get touch?
With the copyright owner.
Please repeat the question.
Of any work.
With the copyright owner.
How can I get in touch?
If it is, yes. If it is publisher, then you can contact with the publisher's contact list, and if it is the author, there must be author information. You can contact with them also.
Okay. Then Pritam Das asked, what is the difference between digitization copyright and cyber copyright?
Digitization copyright and cyber copyright. Yes, it is a really important question. So yes, yes. Actually, digitization actually it comes under the intellectual property right, and which is not actually comes under the in case of literary works or in case of other works, it is not comes under the computer programs or database like that. So computer programs and other cases like databases, like online thing, internet IP, this all comes under the cyber law. It is not actually periphery of the copyright law. For the content only, it comes under the copyright law. So there must be a difference.
Okay. Okay, ma'am. One question is, may we scan some pages of a book and distribute it to academic purposes?
Pardon?
May
Hello?
we
Yes, please repeat.
can you
Please
hear me, ma'am?
repeat your question or repost. Please forward your question to my private chat box. It is not audible from your end.
Hello.
Yes?
Can you hear me, ma'am?
Yes, I can hear
Hello.
you now. Yes,
Can
yes, I
you?
can hear you now. Please,
Yeah, ma'am.
yes, please
Ma'am, these questions
repost
are.
the question. Yes.
The question was that can we scan some pages of a book? If yes, then how many pages?
Hmm.
Which will not violate the Copyright Act?
Actually, it is not about page. It is the portion of the page. With the sometimes it's 1/3 of the entire work, and in case of 2/3 of the work for the research purpose or for the academic purpose, you have to seek permission from the higher authority. And in case of 1/3, you can use that 1/3 of the entire work. It is not the violation of the copyright.
Okay, ma'am. And Topendu Vishwas asks that if any book or document which is out of print right now, can we print it from PDF?
If it is not available in India or in the in Indian as per Indian copyright law, if any book or any printed form is not available in Indian perspective, then not more than 3 copies may be permitted to digitize. It is not about copyright infringement.
Okay, thank you, ma'am. I think we are at the end of all the questions. So now over to Bandana, ma'am. Uh, Bandana, ma'am, can you hear me?
Yes. Okay.
Yeah.
Thank you. Thank you, Dr. Bernali. I think we enriched ourselves from her nice presentation. Now we have reached the end of the session, and now is the time of vote of thanks. So, firstly, I would like to thank our Honorable Chancellor, Registrar, Brainware University, and Principal Sir of Brainware Group of Institutions. Next, I would like to thank our speaker, Dr. Bornali Raichaudhary, for her nice presentation. Next, I would like to thank our entire library team for their heartiest support. Next, I would like to thank Sujan Bandhu Chakraborty for his technical support and Biplab Chandra for other support. Last but not the least, I would like to thank all of our participants who make the webinar very much successful. We hope we will get back to you with soon with our next webinar. to you. Thank you very much. Thank you, Shankar sir. Thank you, our Prohisi sir,
Thank you.
Sujan sir. সবাইকে thank you. Okay, thank you, Barnali madam.
Thank you very much to all of you.
Thank you, ma'am.